May I be permitted to mention a matter which gone out of list from the April, my lord. From the month of April, the matter gone out of list. It is appearing in the list from September 2024, my lord.
Why did it go out of list?
My lord,
Why did it go out of list?
I don't know.
You didn't appear, maybe. দেখে নিও যদি
It is
থাকে
senior
from my
citizen,
list
my
এ। Are you mentioning upon notice? No, no, no. Mention upon notice. It has gone out of list.
WPLRT matter. WPLRT matter.
WPLRT, we don't have the jurisdiction. Determination, we do not have. Yes.
May I have your lordships kindly for inclusion of a matter, but this was supposed to appear on 28th March 2025, my lord. For some reason
It is WPST.
it is FMA number 336. This is regarding the
Mandamus appeal
my lord,
against single judge's order.
my lord.
What happened?
My lord will recall that this was that matter pending before the Supreme Court, my lord, but had kept it after 2 weeks to inquire about the status, my lord.
Yes, then what happened? Supreme Court disposed of.
And not disposed
Then
of.
why
But,
you are mentioning, sir?
but
Wait
if,
for 2 weeks and mention. Yes.
My lord, may I be permitted to mention this matter for inclusion assigned matter? This I have mentioned in the month of March. It was in the February list. Then I mentioned in the it was not appearing in the month
No,
of
no,
March.
we kept it in the kept it aside, unnecessarily publishing the matters. We kept it very
kindly-
good. You give the copy.
I'm grateful, my lord.
Assigned matter a combined list.
May I permit to mention
Lord, on habeas corpus matter for inclusion, my lord. New matter.
Fresh motion.
Fresh motion, my lord.
Fresh motion, it will appear COVID date আছে. When this
Date was earlier, my lord. Before on 17th of
Justice
18th.
Banerjee.
No, my lord, before your lordship. It was filed after 10th of
Oh,
determination.
all right, give it. Yes, so the heaviest
Lordship, may I
corpus.
permit to
Lordship,
mention
may I be permitted to mention, Lordship, one appeal under section 19(1)(a) of the Contempts of Court Act.
আমাদের আছে না ইলিয়াস? হ্যাঁ? Are you mentioning about notice?
No, Lordship.
Give a notice and mention.
Moving it for the first time? Are you moving it for the first time?
Yes, Lordship.
This is a fresh application.
Yes, a scan 1 is pending, Lordship.
No, no, this contempt order, contempt application was filed alleging violation of which order?
The details I do not.
You don't know. Have you given notice in mentioning this? Anybody appeared?
I think no, Lordship.
Please ascertain, give a notice and come and tell us on the next week. Yes?
Inclusion of habeas corpus illegally detained under PIT NDPS Act, my lord. Inclusion of this matter.
Habeas corpus in custody under NDPS. What
PTA.
habeas? Huh?
PIT NDPS Act.
Prevention of corruption.
Prevention of illicit
Prevention.
trafficking, narcotic drug.
So it is a fresh matter or it was hard earlier?
No, I think it's a fresh matter.
You think? Then we if you think so, how can we ask for enlistment? Please go through the brief, ascertain, give a notice to your other side and mention.
Lordship,
Habeas corpus of which year?
This year, 2025.
It was ever hard.
I don't have any.
So please ascertain. If it was hard, give a notice to your other side and come back. Yes.
Lordship, may I permit to mention this is a review application, Lordship,
Of whose
2018.
order?
Honorable Justice Dipankar Datta and Honorable Justice Pratik Prakash Banerjee order, Lordship, and that order already this matter is on assigned before this honorable court, Lordship, by this honorable.
Is it a service matter?
Yes, Lordship. Group 2, Lordship. This is a one petitioner. He is an engaged and a junior lecturer, Lordship.
Who is your other side? Have you given notice?
Yes, Lordship. I am given notice by mail, Lordship. Legal.
No, why the advocate is not
Because
happy?
I have informed that GP office they have not assigned any brief before any advocate, Lordship. So that's the reason I am mentioning before this court.
So you ascertain if anybody has been engaged. Then
They have
give a-
not informed to me, Lordship, who was engaged in
This is an review of which year?
2018, Lordship.
2018 review.
Yes, and already it's appearing in the monthly list of February, Lordship. In
It
this-
was appearing
yes, Lordship, in the
before
monthly
the
list of
other
February.
bench. Before
No,
the
no,
other
no, no,
bench.
this bench, Lordship.
কি বলছে দেখে নিও তো করতে Let us ascertain. Yes.
My lord, may I be permitted to mention a matter? We have filed one contempt application in respect of an order passed in FMA 982 of 2023. Now, my lord, the file pertaining to the FMA is not traceable, and we have served notice to the office of the learned registrar, but no steps have been taken. Your lordship may kindly issue one direction for reconstruction of the file.
That will be done by the concerned registrar, not by us.
My lord, we have served notice upon them, but they are saying that
No. You have to mention before the registrar, learned registrar.
My lord, we
No,
have served notice before the.
Notice service, no. We want reconstruction of the
Yes,
file.
yes.
So reconstruction you have to mention to the registrar.
My lord, they are saying that we need court's order.
Who are saying?
Learned registrar. We went to the learned registrar. Registrar administration.
Then what has happened? The file has been misplaced.
Yes, my lord, it is not traceable.
You are the appellant.
We are the appellant.
When was it last heard? কিভাবে জিজ্ঞেস করবো তো এগুলো?
My lord, FMO.
Ask your clerk not to poke his nose in between when you are submitting.
What is this? It's a division bench of the High Court. The clerk's going to submit.
Who is your senior in the matter?
My lord, Dipankar Shah.
Uh-huh.
Dipankar Shah.
Dipankar Saha.
Yes.
Ask him to come and mention. Ask him to come and mention on Monday. Yes. Yes, mention it.
Yes, Your Lordship, may I have, this is a appeal against an order passed in a contempt application, Your Lordship. This was moved for the first time before the division bench, before Justice Bakshi, and there we were directed to serve afresh since the respondents were not appearing. We have served afresh, Your Lordship. Thereafter, the determination is changed. I'm mentioning for inclusion in
Any
the list.
advocate engaged on their behalf.
Your Lordship, not till date, Your Lordship.
Near now. Yes, call the list.
Lordship, may I say something, Lordship? The matter which I have mentioned, Lordship, it is appearing for the first time, Lordship. No, I have seen from the e-court services, Lordship. Nobody is appearing. This is for the first time hearing. I am praying for inclusion, Lordship.
What is the can?
Madam, what did we ask you?
Yes.
That go home, study the brief, give a notice and mention. You cannot be so impatient. No, junior counsel. Take the file from your senior, go through it, learn what is the matter, and then properly mention it. Yes, call the list.
Well, I am for the petitioner, appellant.
My lord, Mr. Owen Banerjee is appearing for the state, my lord. My lord, some personal difficulty, he has not come to court, my lord.
He is not the effective respondent. Mr. Chakraborty is there. Yes, you are there. ওই দেখো জানেই।
My lord, I am sorry, my lord. Item number 2, my lord.
My lord,
Item number one.
কি নাম হচ্ছে অমলকান্তি সেন, appear before for CSTC.
ও আচ্ছা আচ্ছা।
That is 345. এক নম্বর।
I am appear for this.
এটা এক নম্বর item তো।
You are appearing for the department.
ওই তো সঞ্জীব দাঁড়। Sir, why you are praying not? This matter is appearing for the third time.
How many charge sheets were there? How many charge sheets were there? Are you there in the matter? Are you briefed? You're not briefed. Sorry? Who's appearing for CSTC? And you said you're not ready, you're asking for time. Now you're saying you're not briefed.
Mr. Sen appeared.
Also, he appeared alone, Mr. Sen.
How many
Also,
charge
he
sheets
appeared.
were there?
My lord, there is very hidden things. 3 charges are there. 343, 296, 260, and all are conflicting.
There is no mention of 2961.
Yes, my lord, that is my difficult. That is the entire thing I set out in my supplementary. Also in can 1 and can 2.
What supplementary?
when we have on leave granted by this honorable court, I filed the affidavit and entered it into the paper book.
Place your case. Yes,
And
let us
I
place your case. Argu, sir.
no, sorry, sir. I'm showing.
Just remind us what was the matter. Key supplementary দিয়েছে
Supplementary affidavit at page number 38 of the paper book. Page 38 of the paper book.
Page 38.
হ্যাঁ,
Supplementary.
paper book, this affidavit is included in the paper book.
Oh, include. Very good. Yes. No, first was the order impute. Which order are you challenging?
Page 30 and 31.
Yes. So where is the order of punishment in the disciplinary proceeding? When was the punishment order passed?
That is at page 23A of the paper book. This is legible copy and 23 is the actual order.
Date same আসছে। সেটা কত? First sheet হচ্ছে 29 22 পাঠানো। নিচে কোনো কিছু পাইনি। First reply 343. তারপরে পাইনি তাই No, 296128. Page 22. সেটা পাইনি। When was the first charge sheet against you?
First charge was, my lord, 343.
So 22nd May 98.
It is undisposed. It is at page 46 of the paper book. 46 and legible copy 46A.
In reply this 48. কি ওকে রিলিফ দেবে বলো? What relief we will give you, sir?
Yes, my lord, every day this thing happens. On the last occasion, my lord was opining to ask the Mr. Sen that you please make some further payment so that he can be compensated to some extent. So Mr. Sen didn't appear. It was my lord's version.
Where is Mr.
My
Sen?
my
My lord, in this
my
matter,
submission-
Mr. Amul Kulashiri is appearing for Calcutta State Transport Corporation. He is not able to attend the court today due to some personal emergencies. My lord, kindly adjourn the matter for 2 weeks. Yes, Amul Kulashiri.
You've received that 59 and 70,000 or whatever you have, that you've received.
Yes.
In terms of the order, you've received that amount.
No, my lord asked what amount can be paid. Almost Sen was to expose today, submit today what amount they can pay further.
Did you get? You don't know how much your client
The
got.
order says
My lord,
52 and 74. Have you received that amount?
No, I received the pension and the gratuity and payment receipt in
How much
22.
is that?
There is 1,25,000. In 22, I received after the retirement period. But that was not my case before the single judge. However, that has been paid. And 1 month further pay rupees 2514 without any accounts. But actually, that amount is denied by my client because he wants to say that 39 months area salary is due. And my humble submission is, my lord, a date may can be fixed for final argument when I can submit my written argument, and my lord 1 and 2 was filed, can 1 and 2, that has not been replied by them. So I fix a date so that I can submit a copy of the argument of 3 or 4 days before and give a reasoned judgment.
This come
ও
to the
দেবে না
order.
তো।
Come to the order, page 30.
ও বলবে না তো।
Thank you. Complaint হয়ে গিয়ে থাকে, আপনি জানাচ্ছেন।
Yes.
Have you received this amount of 50?
Yes. Received not in 16, received on 22.
To accept furniture.
Retirement was 31st August 21.
Strictly speaking to
You can only question the quantum, accepting the order of punishment.
no, subject to acceptance. He has not accepted.
No, accept furniture.
Punishment I didn't accept.
Did not accept.
Amount. Just accept revision, that payment due. Accepting the order of punishment. Upon accepting the order of punishment.
Punishment not accepted.
Two weeks. Complete your service in the meantime. Have you served the copy?
Yes, served. 1 and 2 served.
So when can he come?
My lord, after 2 weeks.
2 weeks.
What is he doing?
Well, 13 May can be date fixed because this month I shall file judgment argument with judgment some I rely upon, and thereafter a reasoned judgment is sought for.
Yes, 2 weeks. Same heading.
Full lordship.
এই can 1 or can 2
If they want to file reply 1 and 2, they can file.
Nobody is there. They have not prayed for reply. What will say? Have you served?
Yes, on the very day I've served.
Yes, where is his junior? You have got those copies.
He does not.
Tell your senior if he has got those copies, ask him to file reply in the meantime.
Yes, can 1 and 2 have served on the same day.
ওইটা কি দুটোকে আনিয়ে নে।
Probably it is recorded also. Maybe.
Yes, next.
I'm grateful.
Your Lordship, union is being led by Mr. Jidadas Chakraborty. For medical reason, he is out of station, Your Lordship.
Medical reason.
For medical reasons, Your Lordship.
I am appealing for respondent number 429.
Praying for not today.
My lord, I am the petitioner, my lord.
এটা হচ্ছে প্রমোশনের ম্যাটার।
My lord, senior advocate of the appellate side, Mr. Madhusudan Dutt, got the brain stroke, my lord.
Huh?
Brain stroke, my lord. Several attack. Madhusudan Dutt, my lord.
When?
11th April.
Now
Left side fall, my lord. Need 1 month, 4 week time, my lord.
How is he now?
He is now best, my lord, but doctors said the treatment is going on. Rest for the 1 week.
I do not have any email. Thank you.
1 week should be okay.
My lord. উনি বলছে কি এক মাসের সময় নিতে বলুন 1 week no my 4 weeks my lord
4 weeks বলেন
my lord 4 weeks my lord
You just now said 1 week.
no my lord 4 weeks sorry my lord I said 4 weeks my lord
You are his junior.
yes my lord
Dr. Shankar Kumar Prasad.
Sanjay Kumar Prasad my lord 4 weeks my lord
It will appear after 2 weeks, ascertain how he is, then tell us if he is still sick. We will consider.
then my lord
grateful to
My lord, I appear on behalf of the private respondent.
Who is
I'm-
for the appellant?
my lord I'm appearing on behalf of the appellants in compliance to the last order we are filing the supplementary affidavit and we have also served to the other side so we are also filing the affidavit of service.
My lord, I am also filing my affidavit in opposition. I have served to the other side.
My lord, I'm being led by Ajit Kumar Mishra, sir. He's in court number 41. He's on his legs. My lord, I'm praying for not today.
Why place the case?
My lord, we are
Place the case. Your senior will come and argue. You start. You are the advocate on record.
I'm not the advocate on record. My senior is
Who is your advocate on record?
Ajit Kumar Mishra, sir.
Uh-huh.
Ajit Kumar Mishra. He's the advocate on record. He's my senior.
My lord, if I may, the issue they have challenged is that Article 311 does not apply on. My lord, if I am my lord, if your lordship kindly hears me, the issue will not come in itself. This entire administrative order was passed in violation of an High Court order. There was a High Court order, my lord, that they won't proceed with the administrative disciplinary proceedings without the leave of this honorable court, the single bench of this honorable court.
Which is the order in appeal?
My lord.
15th of March 21.
My lord, the order impugned, yes, my lord, the order of single
March 21.
21.
No. Division में अमृता रोड কি করে
My lord,
জানবে?
it is in the last pages of the can, my lord.
You don't know the date of the order impugned.
No, no, my lord. 12 December 2019, my lord.
Why
I'm
did
sorry.
you say 15th of March?
No, no, my lord. I'm sorry. I'm sorry. My lord. Your lordship may kindly take page 13 of my
Wait,
affidavit.
answer when you are called.
My lord.
So supplementary there, you have used an opposition
I have used an opposition.
and you have filed any reply.
No, my lord. They have filed the
Opposition.
To the
Both petition and the supplementary.
You have filed an opposition.
My lord.
So you have not used any reply.
No, we will file a reply there.
That prayer, that leave was given to you.
My lord, leave was given to file supplementary affidavit.
Yes. Then it was said that reply, if any, within a week thereafter. When did you receive this? When did you receive their opposition?
My lord, on 2nd April.
2nd April. We are today on 17th April. That period has over.
My lord, a short accommodation may kindly be given.
No, how many times will adjourn? You tell us then. Then when a matter comes, you adjourn it for 15 times. We will do in the meantime. There must be a limit to everything. Just there are 2 working days. Huh? It is there was a holiday prior there to a holiday subsequent there to. Now you people are not bothered to do the matters. And we the poor guys, we are sitting here waiting that when my learned advocate will come and make us submission. See what is our state. When you are a junior, when you receive the opposition, was it not your duty to place a draft and get it rectified by your senior? You are in High Court, sir. You are a junior counsel. You use your reply. 2 weeks. In the meantime, you use your.
Grateful, my lord.
মোড়ে চলে
হ্যাঁ আমরা বসে আমার ছুটি করতাম
যত ভেবে বুঝতে
Hello, Lordship.
Hello, you're here.
Sorry, sir. Sir, actually, I am led by Advocate Firdaus Samim, and he is engaged in Supreme Court for SSC matters and work of.
Father, I am representing state matter.
Work of matters, so I am seeking for not today.
He is not. He is more bothered about.
My lord, I am having a small submission, my lord.
Keep quiet.
My lord,
One person is arguing here. Two weeks next.
না একটু টাইম চাইলে এখন থেকে অ্যাডজার্ন স্যানিটাই করবে ওরা যখন মামলা করতে চায় না লেট ইট বি অ্যাডজার্ন স্যানিটাই
Sir,
Are you the appellant? Are you appearing for the appellant?
my lord, may I submit, my lord?
Yes.
My lord, there was a direction from the Honorable Chief Justice, my lord, upon them, my lord, to serve us a copy of my lord. So until and unless we will be served, my lord, how can we take instruction, my lord? If your lordship will see the last order passed by the Honorable Chief Justice, my lord, but there was a direction, my lord.
देखी फाइल का देखी.
My lord, the matter was listed wrongly in Group 9, my lord.
You are for the respondent.
My lord, respondent, state respondent, my lord. We appeared there also, my lord. We have not been served with a notice that this matter has been listed before your lordship, my lord. Since, my lord, we came to learn, my lord, we appeared, my lord. Now, my lord, may kindly see the para 4, my lord. The last portion of the order, my lord.
Is it? 2 weeks for it.
Obliged.
We are not in a position to ask him because he doesn't know anything about the matter.
I understand, my lord. But since my lord, it was my responsibility to address your lordship, my lord. Highly obvious.
Firdaus Samim has not taken you for the Supreme Court matter?
No, sir, I'm first day. First day in the course.
First day.
Your first day today. Achha, so you are a learner.
What is your name? What is your name?
Shoikat Mollik.
Soikat Molli. So you are attending the chamber. You are attending anybody's chamber.
Advocate Firdaus Samim, sir.
When did you pass out?
2024.
24. In this legal profession, there is no learner's license. You have to start from the first day.
Next day you come ready. We'll hear you. Study the brief.
Okay, sir.
Have you seen the brief?
No.
So ask Firdaus Samim to give you the brief. And there was an earlier order that you will serve the application filed in connection with the appeal to the state advocate. Here, state
Not
advocate.
there, here, on the screen.
His name is?
Anand Farmania, my lord.
Write
I'm
down.
led by Mr. Shen Gupta in this matter. Suman Shen Gupta.
Anand Farmania.
Farmania, my lord.
You sit in which bar association?
My lord, High Court Bar Association, my lord. I'm a member of High Court Bar Association, my lord. I'm led by Mr. Suman Shen Gupta, my lord. My lord, my clerk is there. He will collect it, my lord.
Which bar association? Which room number?
My lord, 18, my lord.
Bar association, room number 18.
Have you written his name? Room
So-
number 18, you go and serve.
Serve that application upon him and come and argue before us. 2 weeks, yes, next.
My lord, highly obvious.
Lord, 5, my lord, I am for the appellant. Lord, you can remember on last occasion, my lord, I submitted, my lord, supplementary affidavit. This is regarding, my lord, the fixation of the, my lord, employee of the rural bank. My lord, there are 2 parts.
Yes, you are ready.
But only, my lord, I have got instruction in writing from the concerned bank, my lord, regarding the claim of my learned friend. Everything has been paid, and I will satisfy lordship. But certain documents they have not supplied me yet. But that can be supplied if lordship please to ask me. That can be supplied later on. But let them satisfy that
So
they have
if
not.
those documents are given, then you will, then what you will do?
In support of my statement, my lords, the circular and the other etc. point that will be supplied later on, my lord. That is the document. That is otherwise, my lord, from their own case, I shall satisfy lordship, my lord. They are not entitled to get anything.
No, we last time we passed an order
Lordship.
that
Take
they will
instruction whether
furnish all the documents
lordship.
so that you can take necessary steps. What is your instruction?
My instruction that, my lord, to that effect, necessary steps has been taken, and their claim is not
admissible.
Absolutely not, because I shall produce the documents which are supplied.
When will you produce?
Right now, I shall produce before lordship.
Right now, it is
Yes,
there?
but some annexures are not available because the bank is going on year-ending some work.
Ending on.
So no problem. I shall satisfy lordship, my lord. Even just going through this document, my lord, this written.
Then you will not rely upon those documents. Sure.
Okay.
My lord,
কি করবো? শোনার পরে
সব পেমেন্ট হয়ে গেছে।
বলছি এই ডকুমেন্টের
পরে লাগতে পারবে তো?
my
Mr.
lord,
Mukaram,
Lordship,
Have you given a copy of those documents that you wish to rely upon?
that is that can be supplied. So if lordship kindly fix it on next
My lord,
day, Tuesday. In the meantime, I shall collect it. My lord, my learned friend is saying before lordship, my lord, by way of making submission, that they have applied for retirement benefit from the date of retirement pursuant to the judgment passed by the Honorable Supreme Court. And it is their contention.
what we are wanting to know is we have asked you that they will produce the documents so far as we remember.
Lordship, absolutely.
That those
Matlab,
documents will
ID number,
that
ID number that was not given, that I have also mentioned, and PPO that I have mentioned in my supplementary affidavit.
So, Mr. Hussain, what are the other documents you want to rely upon?
Number one, my lord, there are 19 petitioners.
No, we will not enter into the matter if
Yes,
it
the
is
document,
incomplete.
the documents which I want to place before lordship,
That
my
is
lord.
not with you.
Yes, that my.
So unless you give those documents, as my brother says, how they can make their submission? And we last heard it on 27th of March.
Lordship.
Year ending is over.
Lordship, year ending is over.
Then
they have supplied them under the document, their submission in a writing that I can replace. And not only that, out of 19 petitioners who got, so man, only 2 or 3 days kindly give me so that in the meantime I say correct it.
No, we will not give you. You will give it within 3 days to him. Those documents.
Lordship.
Very good. So he will go through that. We finally hear the matter next week. Within when can you give it? Within which date?
My Thursday, my lord. My next Thursday, my lord.
You have used any reply to this supplementary?
No.
Huh?
No.
So you can reply annexing those documents. Problem will be solved.
Okay. Yes. Lordship.
Lordship, kindly recollect. Lordship, kindly recollect, my lord, here, my lord, our at present, our submission.
Just in the CAN application, in the stay application, have you used any opposition?
No.
Then in the writ court, was there any affidavits?
In the writ court, I was not there. Writ
court, there was no affidavit filed. So they must get an opportunity to file an opposition to this.
Lord, that can be, Lord. Only the point is now before your lordship.
Understood. Whatever is your point, we have to decide the matter. Now
My
you
lord.
say that your affidavits were not exchanged before the court.
Lord,
So
I
the
have to
stay
check
application, they have
actually, my lord, it is, my lord, before, my lord, the COVID period case, my lord. So, my lord, I have to check up, my lord. At present,
you
my
don't
lord.
know. Did you file any affidavit? পেনশনারদের মামলা this is an appeal against the judgment dated 2nd July of Justice Ajay Kumar Gupta.
Ajay Kumar Gupta. Judgment. Actually, Malad, here we used Malad written notes of argument, both the bank and the petitioners.
You have annexed that?
No, that no, Lordship, if your Lordship kindly Malad give me Malad some time, Malad, I will Malad.
কত time দেবো বলুন? Since when we are
Malad, because it is come to an end, only one point left. That is, Malad, whether we are entitled to get the 1/3 pension for 17 months. And Malad, other question has already been Malad decided by the Honorable Supreme Court, and that is decided that we will get pension immediately after the date of retirement. The question was whether the employee of the RR Bank will get Malad pension from the date of immediate retirement, or the date fixed by the concerned bank from 1/4/2018. This question, my lord, challenged before your lordship. In the meantime, my lord, in connection with the original petition before the Honorable Supreme Court, a contempt petition was filed. In the contempt petition, my lord, the central government opined and disclosed that no, the employee, retired employee of the RR Bank will get pension as per the regulation of the sponsored bank. That is, my lord, in terms of MO 1993. That has already been accepted. Supreme Court has already passed an order. I have annexed that order in my stay application. So now only left that 1/3 pension. 1/3 pension we have not got from 1/4/2018 to November 2019. As we have applied for commutation in the month of September.
What did the trial judge say about that?
Trial judge says nothing, my lord. Nothing. And my lord, in the writ petition, we have also prayed in prayer B of my writ petition.
You were given pension from 2019.
2018, 1/4/2018.
You were given pension from
1/4/2018.
In terms of the prevailing pension rules. But I think my learned friend is not properly instructed because my lord, out of 19 petitioner, they access
pension given on 18th?
1st April 2018.
1st April 2018.
And my lord, commutation credited to our account November 2019.
So you approached the writ court claiming the benefit of 1/3 pension.
1/3 pension which was deducted from 1/4/2018 instead of November 2019. Since the amount credited
effect from
with
deducted with effect from
1/4/2018
till
November 2019.
So this is the amount you claimed.
My lord.
Now what did the writ court say?
Writ court, no order has been passed in this connection, only the writ court opined regarding the fixation of pension, whether they will get the pension immediately after the date of their retirement or from 1/4/2018. Supreme Court has already decided in terms of the undertaking given by the central government. I have annexed those petition as well as the order. Lord, may I clear before your lordship?
Where are your written notes of argument?
Written notes of argument.
They have also filed a written
my lord. They have also filed written notes.
Have you seen that, Mr. Hussain? Your written note of argument?
No,
You
my
have
lord.
not seen that.
But I have written note of arguments have not been filed, madam.
Then do you we have to know your stand on the basis of the
Yes, kindly,
application and the
we want to file opposition to that effect so that I can annex all the documents in support of my claim. And their claim that they have not got, that will also clear from the annexure or documents, my lord, that they have got it, everything. Even, my lord, they opted out of 9 petitioners are opted. They have received the amount. There are no dispute. They will not come forward before lordship, my lord.
Mr. Raman, learned advocate, submits that
Yes,
My lord.
kindly come to also page 134 of the state petition. You have annexed the exact same document
My
you
lord.
have already disclosed.
My lord.
What is the purpose?
I have the two cut short the proceeding, I have annexed again, because it was my lord. My lord, kindly, I am tendering my apology, my lord.
No apology. I'm trying to understand, Mr. Rahman. Why did you have to annex it all over again? You're just increasing papers for us. Same document.
And madam, annexer, that is page 5. Kindly see, madam.
ID cardটা ওদের কাছে pension payment order
দিয়েছে ওটা তো petition এ already হয়েছে।
হয়েছে, রিপিট করে দিচ্ছে। সহজে নিয়ে আমি পারবো না। So,
And
Mr. Raman, learned advocate appearing for the
obligation, Lordship. Thank you.
I am for the response.
মক্কেলেরও টাকা নেই, মক্কেলেরও টাকা নেই, নিজেরও টাকা নেই।
the appeal. For the
Item number 46. Yes, sir. What is the order you are challenging?
unless single judge, not only single judge, the punishment order and appellate order.
Disciplinary proceeding.
Yes, madam. Punishment order and appellate order. Charge was issued, application. Because notice issue inquiry proceedings are already say completed. Engage the inquiry officer and respondent to appear.
You are for the writ petitioner.
Writ petitioner.
So this appeal is at the instance of Union of India. Contempt has been filed.
Yes, madam. Contempt petition has been filed, and the next date of hearing of the contempt petition is on 24th of this month.
24th of this
month.
Very good. Argu, why will he stay this order?
Lord.
Affidavit was exchanged before the writ court.
Yes, madam. Affidavit in opposition was filed, and reply was also filed.
Have they annexed those in?
Yes, yes, ma'am. In the state petition, they have annexed all those documents. And my lord, with the leave granted by the learned trial judge, a supplementary affidavit was filed by me, enclosing the proceedings of the inquiry. And my learned friend was given opportunity to file opposition to that supplementary affidavit. And they did so. And that has also been enclosed, and my learned friend has filed there. And the inquiring authority, he led the examination in chief all the prosecution witnesses, and he cross-examined all the said prosecution witnesses numbering 9. And that record was filed by a supplementary affidavit with the leave granted by the learned trial judge. And on perusal of that supplementary affidavit, and the learned judge held that there is bias on the part of the inquiring authority, and I also placed on Supreme Court judgment. And
yes, Argu.
My lord, the only question is the inquiry officer cannot cross.
No, you place the order, argue the matter. So those supplementary affidavit has been annexed here.
Yes,
You have
yes,
been
yes.
given copies.
Yes,
Yeah.
I have also copies.
Yes, place the order.
I know page 7.
Yes. Page 7 of the order.
Page 6 is the correction order. Page 6.
Yes. Are you ready, sir? Are you ready? Ready with the matter? Is anybody leading you?
No, my lord.
So you are ready with the matter? You can start then. No. Mr. Das, Mr. Das, have you gone through your records? We are in final hearing. Don't take time after starting.
Next to the
When is your contempt? When is your contempt? Contempt application is returnable when?
Contempt application by in 24 and
24th April.
yeah.
Very good.
Only Kaliman or only
22nd we are keeping it. We will hear the main appeal. Because all the record, all the matters are on record.
Yes.
All the papers are on record. 21st করে দাও না Monday. 21st we will hear.
Record supplementary affidavit and affidavit of service Kaliman recorded.
আচ্ছা the learned একটা order লিখে নাও। Mr. Das learned
Item number 7 and 8, my lord. In both the matter, my lord, I am for the writ petition or appellant, my lord.
But I am filing opposition in one matter, my lord. In item number 8, I am filing my opposition.
My lord, I am filing reply, my lord. Both the matter.
My lord, there are in
And-
item number 8, my lord, also.
Eight.
My lord, your lordship, 7, your lordship has been pleased to give me direction to file opposition. My lord, it is ready. But I am paying, my lord, 7 days time to file the same of the 7th opposition.
My lord, this
Eighth opposition
opposition
is
has
ready.
already been, my lord, served after a lapse of time, my lord. This opposition in respect of FMA, my lord, 14
মামলাটা রেডি আছে করুন
না না সে কথা আমি বলছি না
রেডি আছে করুন
সে ঠিক আছে সেটা আমি কিছু বলছি না
2 weeks, yes.
Sir, I'm Malad, you'll also kindly grant me time to file opposition, my extension of time to file
তাহলে file করো।
Just kind.
item number and 7 and 8, my lord, দুটোই both.
So
This was
both the appeals are
1462, I am filing my opposition.
দাঁড়াও না, both the appeals have been preferred against the same order.
Same order, common judgment.
Common judgment, you were the writ petitioner.
Writ petitioner.
What was the subject matters? Disciplinary proceeding.
One is
Disciplinary
disciplinary proceedings, another writ is for transfer.
No, my lord, transfer that has been, my lord, become
2008.
infractuous, my lord.
2008, Malad, 1461, WP, FMA 1461.
We are wanting to know the order which has been impugned. In both the appeals, it is the same order.
Same order.
Why 2 appeals you have filed?
My lord, common judgment has been passed, my lord, in
You filed 2 writ petitions.
2 writ petitions.
Issues are different, man. Issues are more.
My lord, the present
দেখো,
application.
The appeals being
I am appearing on behalf of the appellant. In this matter,
My lord, I am taking for adjournment, my lord. Senior counsel has not come in last occasion, my lord. Your lordships told that there is one special bench judgment regarding that if overqualification is there, if there is no prescribed
here,
food-
my lord, there is no overqualification. There is a suppression of material facts, and he himself has declared that he is class 8 pass. But whereas he has obtained already, my lord, Madhyamik pass, my lord. I will show the Supreme Court judgment. The Supreme Court has categorically held
not at all
that overqualification is no bar. But whenever to get the employment, somebody has suppressed his qualification and got the employment by way of, my lord, misrepresentation. Not today. My lord, Wednesday, my lord, Monday I have some difficulty, my lord, Wednesday. Next Wednesday. Next.
Deeply obliged, my lord.
Your intent.
Let us respond.
Yes.
Your lordship was saying the order my lord made, last order.
That letter we wanted to see.
Yes.
30th March.
My lord, this order was made upon an application I filed. IA can 1.
Yes.
Lordship will kindly see the can 1. What is the prayer there? Can 1. I filed a memorandum of appeal against an order dismissing my writ application for compassionate appointment, holding that the application was time barred, whereas my contention is it is not. Now, on that ground, the writ application was dismissed. So against the order of dismissal, my appeal. And I have made a very innocuous application. Very innocuous application.
Kindly have a look at page 13 of
Let him file the paper.
Does he want to get the, on this
Only one
application,
thing
does
I
he
don't
want?
know whether why this is being not produced before your lordship. I have the copies, my lord, the applications. That my
I have
lord
the
wanted
copy
to-
also. My lord, I will beseech your lordship kindly to consider as to whether on an application of this nature, the entire appeal will be heard. My lord, I am bound to answer a question. Certainly, I have asked myself, why this application? My lord, we have not yet passed over the colonial hangover in this High Court. We have to file a paper book. And for that paper book, my lord, an order is
Affidavits were
necessary.
exchanged, Mr. Ali. Affidavits were exchanged in the
Everything.
Everything.
Upon a contested hearing.
File your paper.
Yes. I only paid for filing a leave to.
No, Mr. Ali, that was my brother put that question because there was a concession on your part. That is why we wanted to see the letter.
That's all right. That's all right.
That is why my brother.
So that at least one step forward I go.
No, that we can dispose of the appeal. If you have brought the pleadings on record, we could have disposed it of.
If your lordship so
Paper
pleases.
book again, it will.
Well,
No, that you have not done.
It will be more than a justice to me.
No, there's a concession recorded in the impugned order by your clients.
Yes.
Of 30th of March 2021.
That's right.
By which you had said that you are agreeable to take a lump sum compensation in lieu of the prayer for compassionate appointment.
My lord, the question will arise.
Why we wanted to see that communication.
My lord, your lordship can. My lord, I am not, my lord, just flying away. I am not showing it. I am going to show. But if my learned friend opposes
you have
upon
not
an application of
accepted
like that.
There's
Yes.
nothing to oppose.
Right, sir?
This is for us, for our purpose.
Lordship, very well. It is page 32. Yes.
Which page, sir? Where will we find this?
At page 32. This is annexure P8. This was a letter I was asked to. That we shall not, it is not possible for us to give you a compassionate appointment. Why? Why? If my application is within time. And my lord, I am an eligible candidate. When your lordship hears this appeal, I can place before your lordship. Number of people have been given appointment, even after me. No, not only this, till next letter your lordship will kindly see.
Lordships, item number 11 and 12, Advocate Devashish Kundu is for the appellant. Right now, he is out of town due to medical treatment, Lordships. Kindly 1 week adjournment.
2 weeks.
Grateful, Lordship.
Your Lordship, I appear for that.
Yes.
Your Lordship, kindly have a look to the last order.
Canada Bank kudhai?
Anjun Pal was appearing. I have
Eh?
also, Mr. Anjun Pal
He
is
was
appearing.
here yesterday. Yeah, acted Nagpur.
I've also informed him that the matter is appearing in the list.
একটু শুনি কি করবে?
Any matters both sides that is sharing the legal target. Attention. Now on outside.
Any matter where both sides are here? I don't know. No option. দোষটা আমাদের তো, আমরা যদি পারতে লিস্টে দিতে দিই। হ্যাঁ, লিস্টে অন। অর্ধেক জল।
We are there. Okay. Very next matter. Okay. No, and I mean 14. I mean 14. State is not there. AJ.
Item number 13, let it be passed over. I shall try to contact Mr. Pal.
The bad matter?
No, no, it's a good matter.
Good matter. तो देखिए
Last occasion, Your Lordship directed the bank to file an opposition which has not been filed till date.
Oh, it was dismissed with cost.
Yes. And there was a previous direction of a coordinate bench not to initiate any disciplinary proceeding, but despite that direction, disciplinary proceeding has been initiated. And Your Lordship was pleased to pass an interim order on the last day that the bank can proceed with the disciplinary proceeding, but no final order shall be passed without express leave of this honorable court. That was an interim order passed on the last occasion. And directions were given for filing opposition, which they have not filed.
So the subject matter of appeal is the order by which modification was dismissed.
The modification application was dismissed. From that, I have preferred this.
So this is the only modification application dismissal. Your main writ petition is still pending.
Main writ petition is pending. And in the writ petition, I have prayed for stay of the charge sheet. In the modification application also, I prayed for stay of the charge sheet.
So when the identical prayer in
What
the writ-
happened? What happened? This is the third writ petition. The first writ petition was filed. Very briefly, the first writ petition was filed challenging non-payment of overtime allowance. Now that writ petition was dismissed with a direction that the bank.
Just first writ petition was filed.
First writ petition was filed challenging non-payment of overtime allowance.
Yes.
That writ petition was disposed of on 4th of October 2023. The order your lordships will find at page 15. Lordship kindly takes
disposed of on
4th of October 2023.
That is at page?
I'm sorry, not disposed of, it was dismissed. It was dismissed on 4th of October 2023. The order is at page 15.
Very good. Then what happened?
In that order, it was observed that prima facie there is substance in the contention of the respondent bank.
15.
Page 15. The operative portion lordship will find at page 16. The last three paragraphs.
But 15 is an appeal.
Page 15 is an order passed.
Oh, sorry.
In
Yes.
WP 12190 of 2023. This is the first writ petition. Now this was dismissed. Accordingly, there is no scope for entertaining the writ petition being such and such. Liberty is granted to the respondent bank to take action against the petitioner by filing a criminal contempt in accordance with law if so advised. Now, with this direction, the writ petition was dismissed. I preferred an appeal from this order. The order dated, the appeal was disposed of by an order dated 19th February 2024. The next annexure you will find at page 17. Lordship kindly takes page 17 and just read two paragraphs from the order passed by the coordinate bench.
Which paragraph?
Paragraph 4. The learned single judge.
Para 4.
Para 4. First is para 4.
Yes.
The learned single judge, on consideration of the report, observed that the record of the bank demonstrates prima facie interpolation and fraud committed by the writ petitioner without giving any opportunity to the writ petitioner to respond to the said report in which allegations have been made against the writ petitioner. It seems, next page, your lordship. It seems the learned single judge accepted the submission made on behalf of the bank regarding interpolation and on that basis granted liberty to the bank to take action against the petitioner by filing a criminal contempt. However, the impugned note at the same time also record that the attendance sheet shows that the petitioner worked overtime. The learned judge has accepted the contention of the respondent bank that the claim of the petitioner of the excess amount is unwarranted and unjustified. However, it is overlooked that that for almost 2 years, several communications have been made through proper channel to the manager of the bank claiming overtime by annexing photocopies of the attendance register. The manager seems to have not responded to any of the representation made by the writ petitioner. Now, lordship, not reading the entire order, lordship will kindly take page 19.
No, next para kindly read. In our view.
In our view, the writ petition ought to have been decided by directing the parties to file affidavits and by giving an opportunity to the writ petitioner to respond to the report filed by the bank making certain allegations. Without giving any opportunity to the writ petitioner to deal with the allegations in the report filed by way of an affidavit, no such liberty for filing a criminal complaint could have been granted.
That bean is is missing.
Could have been granted, bean is missing. The next paragraph, the writ petition is able to demonstrate that in spite of repeated and numerous communications addressed to the manager of the bank for almost 2 years, giving particulars with regard to date and time for which he worked beyond office hours. It was for the bank to respond such allegations and deny the claim based on record. The attendance register prima facie shows signature on each page by the manager of the bank. It is thus for the manager of the bank to explain under what circumstances he had signed the attendance register, showing the entry and exit time mentioned by the petitioner in the attendance register. After all, the manager of the bank is the custodian of all documents. For the last 2 years, the bank did not find it necessary to issue any show cause notice alleging interpolation or overwriting of the record by the writ petitioner. And it was only after observation was made by the learned single judge that a disciplinary proceeding has been initiated. In our view, the order of the learned single judge could not form.
When was this disciplinary proceeding initiated?
First, it was a show cause was initiated. A show cause was served on me. That is, during the pendency of the appeal, a show cause was given to me that you kindly show cause why we will not initiate disciplinary proceeding against you. So here, initiation of the disciplinary proceeding means that show cause. Now, paragraph 8. In our view, the order of the learned single judge could not form the basis of the disciplinary proceeding as the issue raised in the writ petition is first required to be decided upon exchange of affidavit by the parties. In view thereof, we set aside the order dated 4th October 2023. We permit the writ petitioner to file an affidavit taking exception to the report within 2 weeks from date upon prior service to Mr. Pal, learned counsel for the bank.
Yes.
So by this order, the Honorable Division Bench was pleased to hold that no disciplinary proceeding or any action can be initiated at that stage before the writ petition is heard of.
That is paragraph 8.
Paragraph 8.
Please place that. In our view,
the order of the learned single judge could not form the basis of the disciplinary proceeding as the issue raised in the writ petition is first required to be decided upon exchange of affidavits by the parties.
very good, but they have issued an independent show cause.
That was during the pendency of the appeal. And
Very
that
good.
show cause, here initiation of the disciplinary proceeding means that show cause. Now, after this order was passed by the Honorable
No,
Division
when
Bench,
it is said, in our view, the order of the single judge cannot form the basis of a decision,
Disciplinary
and the order was set aside.
set aside.
So where is that does not render the show cause bad.
So, Your Lordship, you will kindly see
Let us read together. In our view, the order
the
of
previous
the
paragraph, Your Lordship.
yes,
The previous paragraph, the last line. For the last 2 years, the bank did not find it necessary to issue any show cause notice alleging
you are reading?
interpolation or overwriting of the record by the petitioner. And
Yes.
it was only after an observation made by the learned single judge that a disciplinary proceeding has been initiated.
When?
During the pendency of this appeal, the show cause was issued.
So the show cause has not been set aside by the appeal court.
No, the next writ petition which I filed, that is challenging the show cause and the suspension.
So
That's the second writ
from
petition.
this order, the show cause has not been set aside.
But
Your argument is that the show cause is in fact in view of the learned single judge's order.
yes,
But the appeal court did not go into that.
no,
Show cause was not disturbed. So you challenge the show cause.
yes, because the show cause was issued after the order was passed by the learned single judge
Maybe.
and during the pendency of the appeal.
Maybe now the show cause notice was issued to you. What is the date of the show cause notice during pendency of the appeal? That you
Yes.
challenged in the next writ
In
petition.
the next writ petition.
Achha,
I
that is
challenge
the
the show
second
cause.
writ.
Yes. The
Second
writ
writ petition challenging the show cause.
show cause and the order of suspension.
Show cause and suspension was same date.
No, the suspension order was issued
Both you challenged.
both under challenge in the second writ petition.
Show cause date you don't know.
Show cause, I give you lordship, the suspension date is 11th of October 2023.
11th of October 2020. Very good. Then what happened?
Now, in the second writ petition, your lordship kindly takes page 21. The order passed in the second writ petition. This is 5th of July 2024.
21 is 5th of July.
5th of July. There is the order passed in the second writ petition.
Yes.
However, Lordship, after filing the writ petition and before the writ petition could be taken up for consideration, during this interregnum, the suspension was revoked. The suspension was revoked on 13th of May, 2024.
So during pendency of the writ.
During pendency of the second writ petition, the suspension order was revoked. Now, Your Lordship, kindly see the second writ petition. The order passed therein. On 5th of July 2024, that is at page 21. Supplementary affidavit affirmed on 20th June 2024 by the petitioner and filed in court is taken on record.
There you annex the revocation order, maybe.
Yes, there I have annexed the revocation order. I have challenged the second writ petition was filed assailing the suspension and the show cause.
So part of the relief you opted.
Yes.
Now show cause.
Now only remains show cause. And the first sentence, the supplementary affidavit affirmed, this supplementary affidavit was
Bringing
for the purpose of bringing on record the charge sheet that was issued.
Charge sheet was issued during pendency.
Pendency of the second writ petition.
What is the date of the charge sheet?
The date of the charge sheet, Your Lordship, 20th May 2024. But since I received the charge sheet after filing the second writ petition, the charge sheet was not a part of the second writ petition and it was not under challenge in the second writ petition. The petitioner is working as a clerk in Canara Bank. The petitioner filed a writ petition being such and such. This is the first writ petition, ventilating his grievances against non-payment of overtime benefit. The said writ petition was dismissed by an order dated 4th October 2023. The petitioner challenged the said order by filing an appeal. In between dismissal of the writ petition and filing of the appeal, the petitioner was suspended. The order dated 4th October 2023 dismissing the writ petition was set aside in appeal by an order dated 19th February 2024. As a consequence whereof, the previous writ petition is pending for final adjudication. I am told that the bank has already filed this affidavit in the said writ petition. The petitioner says that during the pendency of the previous writ petition, the suspension order has been withdrawn. However, charge sheet has been issued against the petitioner on 20th May 2024. The petitioner in this writ petition has challenged the suspension order and the show cause letter. However, the suspension order having been withdrawn, the relief claimed for setting aside the suspension order is no more available to the petitioner. The show cause after the petition's reply thereto has culminated into the charge sheet. The show cause letter as on date does not have any independent existence but has to be looked into in the context of the charge sheet. The petitioner has challenged the charge sheet by filing the supplementary affidavit. The issue whether by way of supplementary affidavit the charge sheet can be challenged in this writ petition is required to be gone into. At the same time, if the employer is permitted to alter the situation on a regular basis, it will be a supervening impossibility of the employee to ventilate his grievances. In the aforesaid facts and
what is the meaning? At the same time, if the employer is permitted to
alter the situation on a regular basis. Because first, they have issued the show cause notice during the pendency of the appeal. Now, after the appeal, when I filed this writ petition, they issued the charge sheet. They revoked the order of suspension. So they are changing their stand every day.
In the aforesaid facts and circumstances?
After hearing the parties and considering the materials on record, I am not inclined to interfere with the charge sheet at this stage because the charge sheet was never under challenge. It was only brought on record by way of a supplementary evidence. The disciplinary proceeding on the basis of such charge sheet has to be brought to a logical conclusion by following the applicable rules and adhering to the principles of natural justice. The bank will be free to proceed with the disciplinary proceedings and the petitioner shall participate therein without prejudice to his rights in the writ petition. The disciplinary proceeding should be brought to a logical conclusion, but the final order that may be passed in such disciplinary proceeding should not be published or made known to people at large and be given effect to by the bank without express leave of this court. The matter requires to be heard on affidavit and there were directions for filing for exchange of evidence. Now, this is the order passed in the second writ petition.
So the order of which you are seeking modification.
No, this is the order passed in the second writ petition by which I have challenged the show cause and the suspension.
Very good.
Now, since the charge sheet was not under challenge in this writ petition and I only brought it on record by way of supplementary affidavit, in the third writ petition, I challenged the charge sheet. The charge sheet that is challenged in the third writ petition.
What was the necessity, Mr. Majumdar?
Because I could not take the...
Because court accepted that.
Court accepted that
and gave you a protection.
Gave me a limited protection. but the charge sheet itself is bad and has to be stayed. There was no stay on the charge sheet. That is why I challenge the charge sheet. I'll show you, Lordship. Apart from the order passed by the Honorable Division Bench, there are other fallacies in the charge sheet which I will show, and I shall establish that how, from the very beginning, the disciplinary authority was biased, and I will not be able to get a fair trial or independent trial in such circumstances. I shall show you, Lordship, from the charge sheet. Now,
No, so challenging the charge sheet, third writ petition.
Third writ petition. Now, in that writ petition, an order was passed on 18th of November 2024, which your Lordship will find at page 85. So surprisingly, when the writ petition was moved, the third writ petition was moved, it was not brought to the knowledge of the learned single judge about the previous order by which an interim protection was granted. It was not brought to his Lordship's knowledge.
That no final order shall be passed.
Yes, so that is why in this 18th November order, his Lordship was pleased to direct exchange of affidavits, but chose not to pass any interim relief. Only relief is any disciplinary proceeding that may be conducted on the basis of the charge sheet, being the subject matter of challenge, shall abide by the result of the writ petition. So the interim protection now stood modified by this order, which prompted me to file the modification application, which was dismissed, and that is why I am before your Lordship, from dismissal of such modification application.
Now show us the order.
The order under challenge, your Lordship.
Modification order, the page 85. Naki.
No, page 85 was the initial order. The order impugned, your Lordship will find at
Modified,
page
that is
112.
Page 112. Modification application you have annexed.
Yes, I have annexed.
First show us that.
Page 87. There is an application for modification of the order passed on 18th of November 2024.
Page 87.
Page 87. It starts from page 87. Your Lordship want to see the prayer. The prayers are at page 95. What was my prayer in the modification application? My prayer was pass an order modifying the order dated 18 November 2024 by staying the operation of the charge sheet dated 20th May 2024 and direct the respondent bank to refrain from acting or continuing to act on the basis of the charge sheet dated 20th May 2024. There was a specific prayer for stay of the charge sheet. I have 3 submissions regarding this charge sheet, why it should be stayed.
Now show us the order impugned.
Yes, the order impugned is at page 112. This is an affidavit of service is taken on record. This is an application for modification of the order dated 18 November 2024, by which, after hearing the parties and considering the materials on record, this court found that there was no scope for passing any interim order at that stage. The matter was directed
Just
to be...
one moment. In the second writ petition, in the third writ petition in which it was said will abide by, you did not annex the earlier order of the court, which was passed in the second writ petition?
No, that was not brought to the knowledge of the court. That is the whole issue. Everything starts from there, because in the second writ petition, an order was passed giving me an interim protection. On the third writ petition, where I challenged the charge sheet, I don't know why.
The single judge modified the earlier single judge's order.
Yes.
Without being
I will not
apprised
say
of the
modified, because if the order has to be modified, then he has to be aware of that order. I will say that it was the fault of my predecessor that he did not brought that order to the knowledge of the learned single judge. That is why, if that order would have been brought, he would have passed the same order, because it's identical, challenging the charge sheet. Read the entire order.
Yes. By the instant.
By the instant modification application, the petitioner seeks for an order of stay of operation of the charge sheet dated 20th May 2024 and to further direct the respondent bank to refrain from acting or continuing to act on the basis of the said charge sheet. The petitioner initially filed a writ petition being WPA 12190/2023.
This is the fact which has
the entire fact. Now, the operative portion of the order.
114 second paragraph.
Second paragraph, third paragraph, Your Lordship. This modification
No,
application.
there is no court return day finding that there is no.
Read the second paragraph.
In the previous writ petition, that paragraph. In the previous writ petition being WPA such and such, there is already an order that the disciplinary proceeding in terms of the charge sheet dated 20th May 2024 shall continue, but the final order will not be published or made known to the people at large. There is no question of staying the charge sheet dated 20th May 2024 containing the articles of charge on the basis whereof the disciplinary proceeding is being proceeded with. Moreover, as held in AIR 2012 SC, mere issue of charge sheet does not affect the right of an employee. This modification application, therefore, is an abuse of process of law as also of court. This application was mentioned referring to the Division Bench order dated 19th February 2024 for being brought into the list on urgent basis. The order of the Division Bench dated 19th February has no application to the facts of the present writ petition or the modification application. The said order was placed before this court in the previous round of litigation, and this court, after considering the same, has passed the order as aforesaid. By seeking stay of the charge sheet dated 20th May, the petition is actually seeking stay of the disciplinary proceeding, which has been considered in the other writ petition being WPA 13420/2024 and not granted. The modification application being Can 1 is therefore dismissed with cost assessed at 500 gems to be paid by the petitioner to the High Court Legal Services. It is made clear that unless the cost is paid, the main writ petition shall not be heard. So, challenging this order, I have approached Your Lordship.
So you did not charge sheet, you brought it to the notice of the court, which was issued, that order which was shown.
The charge sheet was challenged in the third writ petition.
No. You may have challenged in the third, but
The
you
second
brought
writ
it to
petition,
the
yes. In the
notice
second
of
writ
the.
petition by way of a supplementary.
So there you did not take any, that was not challenging the charge sheet.
No, I could not have.
So you should have taken that ground there. When you brought the charge sheet on record, that supplementary affidavit which you pointed out.
Yes, that has been recorded. Your Lordship, kindly see the order passed in the second writ petition at page 21. Yes, Your Lordship, can you see page 22? The first paragraph, the end of the first paragraph. The issue whether by way of a supplementary affidavit the charge sheet can be challenged in this writ petition is required to be gone into.
But that was not gone into.
No, that was not decided.
That was
There
not
was direction
decided.
for
You did
affidavits.
not prefer any appeal against this order.
I did not prefer it.
Then Mr. Mojumdar.
I have challenged the charge sheet in the third writ petition.
How can you do so?
Kindly see at page 22, the last paragraph.
In the aforesaid facts and circumstances, after hearing the parties and considering the materials of record, I am not inclined to interfere with the charge sheet at this stage.
That's already decided. Yes, already.
Charge sheet was never under challenge in the writ petition.
No, but
So
that's
that
before
point cannot be decided.
That is before the learned judge.
That was before the learned judge by way of a supplementary affidavit. I
But
only brought it
you
on
did
record.
not, Mr. Mojumdar, you did not challenge this order. On the contrary, you obtained the benefit of that order.
Yes.
So you can you have to
obtained a partial benefit.
You cannot eat both sides of the cake. No.
From the very beginning, it was my contention that they cannot proceed with the disciplinary proceeding. The charge sheet should be stayed.
Right. That was not stayed.
Not stayed.
That you are not aggrieved. Instead, what you did, you filed a fresh writ petition challenging the charge. Your writ petition itself is bound to fail.
Because I
Because
understand.
your challenge against the charge sheet that don't proceed with the disciplinary proceeding, that has been negated by a single judge. Now, if you have not preferred any appeal against the same, how can you expect the judge in the third writ petition to again interfere with the charge sheet that now don't proceed with the disciplinary proceeding? What is your explanation to that?
We have
Best thing is, we will dispose of the appeal. We will continue the interim order that has been passed by us till the disposal of the writ petition.
Disposal of the writ petition. Not sure. Because I had threefold submission that why the charge sheet is bad in law. The first ground
But
was
that could have been gone into that. There are two ways. Either you could have highlighted it in an appeal, or you can highlight that in the writ petition also, which is still pending. That the charge sheet is a vague one or it is biased one.
charge sheet is a bias. There are three. Charge sheet is a bias because it has been issued with a predetermined mind.
So very good. That will be decided, Mr.
And charge has been issued after 8 years. Stale charges.
Now, what is the stage of the disciplinary proceeding?
Disciplinary proceeding, the inquiry officer has directed the bank, the presenting officer, to submit his brief to some, but he has not
We will
submitted it.
direct conclusion of the proceedings as early as possible.
But no final order to be passed. Should be some interim protection, because otherwise they will pass the final order.
No, we will say that they would be at liberty to pass the final order, but the same will remain stayed for a certain period of time so that you can challenge this.
Final order will not be published from here to the people of people.
Right. সেটা যখন চ্যালেঞ্জ করে এবার শুনানি হয়ে যাচ্ছে। Writ petition overtime, all are within this charge sheet maybe, because they must
That
have.
the first writ petition is non-payment of overtime allowance. From the second writ petition
So
onwards,
non-payment
charge
of
sheet.
overtime allowance is a separate issue.
Separate issue.
That will be decided in that
That
upon exchange of it.
I can withdraw the second writ petition. I can withdraw the second writ petition. And
This was no suspension has gone.
Suspension has been revoked.
Showcause has culminated
Into
in
the charge sheet.
so you can withdraw the second.
I will withdraw the second. Your lordship kindly adjudicate the third.
Third is challenging the charge sheet.
Third is challenging the charge sheet.
So why we will adjudicate? We will say that in the said conspectus, we are going to dispose of the appeal which you have filed challenging the modification application. We will say that you will be given every opportunity to participate in the disciplinary proceeding, and they will complete it and pass the final order within a particular time. But on the same will not be given effect to for a particular period, so that if it goes against you, you can decide whether to prefer statutory appeal or come to the writ court and obtain a stay.
That
Finished.
case, subject to lordship's correction, in that case, that will again lead to another proceeding.
Why?
Because they will find against me.
But you are considering the flip side. The order will be against you.
Yes, that will
So,
definitely
but
be
it
against.
has to be brought to its logical conclusion.
I don't mind bringing it to a logical conclusion. But till such time the charge sheet, whether the charge sheet is a valid charge sheet or not, whether that charge sheet can be
We will
sustained,
keep all
till such
points
time
open.
the point is decided,
All points will be open.
then again I have to prefer a third writ petition, a fourth writ petition rather. If I withdraw the
We
second,
cannot
or third.
allow you to reinvigorate a claim which you lost at the time of moving the second writ petition, where there is a specific observation rightly pointed out by my brother that stay is refused.
Yes, in the third writ petition.
So you cannot go against it.
Only thing that is troubling me, Your Lordship, is that if they are allowed to give effect or implement the order of punishment, if any, then I will again have to prefer an appeal. I will again have to file a fresh writ petition.
There is no other option.
Lordship will kindly Lordship will kindly allow them to conclude this disciplinary proceeding. Let the disciplinary proceeding be brought to a logical conclusion. But till such time the affidavit, till such time the writ petition is decided, because the very issuance of the charge sheet is under challenge. So if an order is passed based on a charge sheet which is not sustainable in law,
so that has been refused, Mr. Mojumdar.
That will be decided at the final hearing stage. The honorable.
Why writ petition will be kept pending? You, whatever points you, suppose in the disciplinary proceeding, order goes against you. In the proceeding in course of submission, you certainly will take a point that the charge sheet itself is malafide.
Yes.
Once you can establish malafide or arbitrariness, the entire proceedings becomes bad.
That whether the charge sheet is arbitrary or malafide is pending before the learned single judge in the third writ petition. So let
that you are withdrawing.
No, I'm withdrawing the second one, which I have challenged the show cause and the suspension.
Third writ petition, no purpose will be served. You can argue that keep the writ petition pending, let this order continue till the disposal of the writ petition. সেটা okay. Writ petition. থার্ড রিট পিটিশনে যেটা এখানে তো রেখেছে থার্ড রিট পিটিশন পেন্ডিং আছে সেখানে স্টেটা ডিফিউজ করেছে তুমি যেটা দেখালে পেজ 100 this is the third writ petition is 13420.
Third writ petition is 17599. 13420 is the second writ petition.
Third writ petition, that order is page 109, na?
Hello, time.
তুমি কোনটায় দেখালে যে
আমি and 1 page 21.
13420 is the second writ petition. এবার সেই রিট পিটিশনে বললো আই এম নট ইনক্লাইন্ড টু ইন্টারফিয়ার এট দিস স্টেজ।
সেটা আবার 15 নভেম্বরে অর্ডারটা হলো নভেম্বরে হয়েছিল।
18 নম্বরে এই থার্ড রিট পিটিশনটাতে না তাহলে সেকেন্ড রিট পিটিশনটা ইজ পেন্ডিং,
সেকেন্ডটা থার্ডটা পেন্ডিং,
all the three writ petitions are pending. First writ petition, the
November abide by the result.
সেকেন্ড রিট পিটিশনটা উইথড্র করে এইটা যদি ও উইথড্র করে নেয়, এইটাতে কি ছিল অর্ডার? এই ইন্টারিম অর্ডারটা আমরা এই পিটিশনের এই অর্ডারটা মডিফাই করি shall abide by the result. No, second petition in substance is a challenging instruction. That issue will be considered in third petition, which is being absolutely. But a third petition is a protection that so that is contradictory to the earlier protection. But it is lesser effect than the first order. First order was not to publish. এখানে বললে অতএব তুমি যদি এইটাকে সার্ভাইভ করো,
না, আমরা এটা 5th জুলাইটা সার্ভাইভ সেকেন্ড পিটিশনের প্রোটেকশন
সেকেন্ড, হ্যাঁ,
নট টু পাবলিশ।
আমরা বলে দেবো nothing needs to be decided in second petition because suspension revoked হয়ে গেছে, show cause has culminated in charge sheet and charge sheet is telling Habeas. Nothing remains to be decided.
become
Why?
infructuous.
Because suspension revoked, show cause has merged in charge sheet.
Gotcha.
So there is nothing to be decided since you have challenged the charge sheet in the independent. We will dispose of your appeal saying that the third writ petition will be heard on affidavits. And till such time it is heard, they will not publish the result. Yeah, that will not inure to your benefit. Because again, you will have to come and challenge the final order.
Yes, in the third writ petition, if I am successful in the third writ petition, if the charge sheet is itself bad, the initiation of the charge sheet is bad, then everything goes.
Where is Anjan Pal?
I have informed him that the matter is appearing in the list yesterday. He was there sometimes back, I don't know. একবার দেখো না, ফোন করে দেখো না একবার। দেখো যে বলছে আসতে পারে।
That Mr. Mojumdar, consider one thing. You are right that if the charge sheet ultimately goes, then the proceeding also will fail. But we don't know the percentage of possibility in that. I think it will inure to your benefit. If you allow if we allow that the final order be passed, and we stay that final order, it will remain stayed for a particular period so that you can challenge the final order. Now, in the final order, there must be an observation that it is not mala fide, it is not arbitrary. That will be subject to the fourth writ petition.
There will be again another round of litigation.
That
So
you cannot help.
the first option. Because
Charge sheet
if
is not a finding, it is not it is a finding on your guilt. It is a prima facie stage. Oryx fisheries, thereafter
yes,
law.
Oryx fisheries, I brought that judgment. I wanted to place that judgment for Justice Mitro that when a
Mr. also knows.
Because when a charge sheet is issued, it has to be issued with an open mind. If an authority issues a charge sheet with a closed mind and with a predetermined mind,
just because Justice Sen give you the protection, now you are talking too much. Yes,
moreover,
then
the
we
charge sheet.
dispose of.
Lordship,
What?
He said that he is not in High Court today. He wants the matter to be fixed at 2 p.m.
2 p.m. we have
There's
another
a bench,
bench.
the South Point matter.
Monday to be mentioned, we will pass our order.
Lordship.
Achha. We have extended.
Only one thing, Lordship. Just
one thing now.
Because if your Lordship decides that Lordship pass an order that the disciplinary proceeding be brought to its logical conclusion, but it should not be published till such time the third writ petition disposed of, that will suffice. Because in the third writ petition, if I am successful, then everything goes, and if I fail in the third writ petition, then automatically they can implement that findings of the inquiry officer or any punishment order. So no party will be prejudiced. I will also have an interim protection. Because everything.
Are you still doing your work?
Yes. I am regularly performing my duties.
What? You are a group D?
I am a housekeeping cum office assistant, a group D.
So you will show your red eyes to your employer.
No.
Don't touch me. High Court is in CC. That will be giving too much of indulgence to your employee. High Court
Bank being an authority always has the upper hand.
No, upper hand over High Court.
Not over High Court, over me. Nobody has an upper hand over High Court. Over me, my client. সেটা তো বলতে পারবো না।
Yes, we have extensively heard Mr. Mojumdar learned
My lord, I am.
কোম্পানি করে এত কোম্পানি তারপরে বলে তুমি কি ঢুকিয়েছো আমরা তো সব জানি না তুমি তো সব জেনেছ কোম্পানি ম্যাটার করে কি করে এসব করলে Shubho. We don't know what will be Shubho in this matter. Shubho no.
My lord, I am appearing on behalf of the appellant.
কোনো অবশ্যই অনেক বড় অর্ডার পাচ্ছে কি অর্ডার দিও
না না এখন এই পেমেন্ট হয়নি এখন আসুন
let us see what you are LIC
No, I am is LIC.
ও আচ্ছা husband expired half হ্যাঁ submit therefore requisition আছে anything action
Some portion has been disbursed.
One and two respondent one is the
Writ petitioner respondent, that is Shoma.
that is the mother
Wife.
and respondent number two is
Mother of the deceased, Shashuri.
so that has been given
No, only payments have not been ushered. Only a paltry portion of 4 lakhs has been distributed.
no 1/3 amount
1/3, that ought to have been 33 lakhs for each. That ought to have been 33 lakhs
Some
for each.
portion has already been disbursed. My lord, due to procedural formalities, the rest portion has not been yet disbursed, my lord. We will disburse very soon, my lord. Kindly allow me 10 days time, my lord, as per my instruction, my lord, because all money is not lying with me because Oriental we have 50 lakhs.
we are not concerned with that we will enhance the rate of interest
My lord, we allow
and we have given you the liberty to pay
my lord, allow me 10 days time, my lord, as per
some
So
formula.
tell your officer
Yes, my lord.
that if it is not done, we are going to enhance the
My lord,
interest
my lord,
and it will be recovered from his pocket.
my lord. Allow me only 10 days time.
No, we believed you. We believed you.
Well,
You means your client, not you.
my lord.
Your client's contention was that I am not responsible for the delay, my lord. Don't give the interest.
Due to some procedural formalities, my lord.
No,
they
no,
have-
no procedural. They are so lackadaisical. They are sitting there. Oh, it has gone to High Court. Let another order come.
Well, I will file status report. Next week, my kindly fix the date. I will,
Status report justifying non-payment of the remaining amount.
I'll file status report upon payment, my lord.
You will have to pay 1/3. Whatever calculation extra payment we will consider in this case.
Fine.
1/3 stated, 1/3 you have not paid for any
One
appeal.
third, 1/3.
As regards 1/3, there is no appeal on your part. Your appeal is on the context of interest.
My lord, my lord.
So why you have not disbursed 1/3?
My lord, kindly allow 10 days time, more 10 days time, my lord, I will disburse my lord.
Until January
This is a,
Well,
you
some
ask
portion
your
has-
officer to come.
Some portion has been disbursed, my lord, kindly allow me 10 days time.
How much have you disbursed?
This is actually
It's for the mother. You are for the mother. How much did you get? 4,60,000.
16. 16.
দেখি দাও তো।
The marked portion is the money that has been received by me.
আমার কাছে এটা নেই just এই তো মাত্র
No, no, not this one. That 4 lakh amount was disbursed by any forwarding letter.
Bank transfer money.
Oh, back.
But why 33 lakhs doing charity?
Mr. Bandyopadhyay, what is the explanation?
Not fair.
As per my instruction, because all money are not lying with this, LIC. My lord, if you kindly see status reports, which I have submitted before the single bench, the 50 lakhs amount has been lying with the Oriental Insurance Company, my lord.
That is your headache.
My lord,
You are
that's
not
why I'm
concerned
not
with that.
I'm not collect the amount from the Oriental Insurance Company within time, my lord.
That
Kindly
is
allow
your
me,
headache.
allow me 10 days time, my lord. Allow 10 days time, my lord.
Who is the person who is responsible? Who is your general manager? Your general manager?
It's a Life Insurance Corporation India. The manager PNIR, Life Insurance Corporation India, Howrah Division. 2 and 3, my lord. The manager PNIR and the chief manager.
Which order you have challenged? 8th January 25. ওই সামনে পাতাটা
দেওয়ার কথা এটা করি এখন মানে
কোনো টাকা কি আগে না 33 What is your entitlement? 1/3 comes to how much?
1/3 it will come around 33 lakhs.
Where do we find it?
My lordship will find a status of payments to be given to us. In fact, it was only to Shoma at that material point of time. For a moment, your lordship, kindly have a look at their own status report. আরেকটা কপি দেন আছে একটু দেন
Payment.
This was handed over to us in the trial bench.
Now, how much does it come to?
Uh,
This is the total amount, Annexure A.
This is the total amount.
Annexure B.
B.
Which is lying with the
A
Oriental
and
Insurance
B
Company.
total.
Annexure B.
Then very next page. Very next page would be. Very next page, lordship will find
a claim of
There is a provision of 24-hour group personal accidental benefit.
of 50 lakhs.
So this is a separate claim.
My lord.
Because he expired.
Now, there's a separate claim. The order has been done on both. As per the trial court order, it has been on both.
Where trial court
Yes.
order said.
Fine. And this was given before the trial bench after this order was passed. 56.
Insurance.
First, with regard to Lordship will find from page 56.
Page 56, yes. So, Mr. Bandyopadhyay, there is no dispute that this person, that 50 lakhs is entitled.
The amount is lying with the Oriental Insurance Company. That's the procedural delay. My lord.
That you are saying,
Yes,
then
my lord.
show us that you have interacted with Oriental, that court has passed an order. If we do not give.
My lord, I will file a status report. My lord, can you allow me?
No, why this negligence on your behalf?
Well, I will take some instruction. Well, I will file status
So
report.
this gives leverage to the officers.
Hello?
Doesn't it? Suppose my near and dear one has expired.
Well,
that is covered under the accidental insurance. I have given my premium to LICI, not to Oriental Commerce. You have taken my premium. And now when my near one has expired, you are saying, oh, we have invested that in VAT. Unless they give it, how can you? This is sheer administrative negligence.
well, allow me 10 days time, my lord. I will disburse my all dues as per my instruction. And in the meantime, I will file status report also.
Total amount, right? 90 আর 60 কত হয়? 30 লাখ আর এটা 6 লাখ, 36 লক্ষ আর 7 লাখ ধরে। 36 আর 60 হচ্ছে 43, 40 আর 4 হচ্ছে 47, 48 আর
Mother of the
9 হচ্ছে 56 lakhs আর
আগের বারে না
70 lakhs আর এটা হচ্ছে 50 লক্ষ, 1 কোটি 20 লক্ষ। 3 ভাগে ভাগ করলে তো তোমার 40 লাখ।
এত কথা কি আমাদের এইটা মাত্র বলে
এটা তো
the mother of the cases.
By our earlier order dated 27th March 2025,
Well, I may not come, my lord. 17, my lord. I will intimate other side, my lord. 17.
Where is your other side?
My lord, she is sitting outside. Well, I will intimate, my lord. I undertake to lordship, I will intimate on Tuesday, my lord. 17. my
If
lord.
we allow you, we have to allow others also. So better you ask your junior to
Very
be
well,
here,
very well, my lord.
and
My lord,
we
may I
will be
par-
having a different
My lord,
bench at 2 p.m. After that, if time permits, we will sit.
May-
We understand, my lord, at 2 p.m. there is another bench.
Yes.
And that is this bench going to resume even after that bench?
Huh?
Good Friday,
We have only one matter, Mr. Ali. In the other bench, we have only one matter.
But
If you are not there, ask your junior to
tomorrow is
mention.
Good Friday, then Easter Saturday.
But today we are on Thursday.
My lord, item number 15, the next
Well,
item.
But the parking lot is totally empty today.
Yes.
Is empty, parking lot.
Oh, achha.
The
I
parking lot is
I
empty.
was telling my lord, if I had been on that side, I would have definitely not come to court.
My
My
lord,
Ulta bol-
it is not better to be so helpful. Work helpful.
If you do not want to
I don't want
any
to
problem, then give us.
No, no, let your junior be
I'll
here,
make
we'll accommodate. That's not a problem.
Yes.
My lord, item number 15 and 22. I am led by Mr. Dibyendu Chatterjee, could not appear before your lordship due to personal reasons. Praying for adjournment, my lord.
Which
The
one?
others.
I am for the
Item number
applicant
15 and 22. my lord.
22.
Let us, if we come back, we will. 15 and
22, my lord.
I am for the 15.
The other side.
sir, you any one of you point it out to us that you are in difficulty, we will consider. Yes.
My lord.